huge risk for anybody who owns rental property. So not only do we manage the property, we advocate on your guys' behalf. This is me at the city council talking against some of these ordinances that we're about to talk about. You see the people behind me, those are the people that are actively working against landlords and who are trying to pass things that are very bad for landlords, which we'll get into some of that stuff. So the focus of today is going to be tenant protections in the city of Ventura. I know some of our clients are here who don't own rental property in Ventura. We appreciate you coming. Most of this is going to be applicable, but there are going to be some specific things that don't apply to you. But don't hold your breath, that could change in the near future as these organizations are actively trying to, go ahead.
Is the unincorporated area of Ventura considered part of the?
No, not the city ordinance that we're going to talk about. You're fine from there. There are other stuff that affects you, but not specific to that. Okay, so I think it's important to talk about the key stakeholders in these negotiations, if you will. There's, in my opinion, 4 parties. So you have the property owners and the landlords, which is, there's a decent representation here. We have the tenant advocacy groups, which I don't believe they're here. Mainly CAUSE, which stands for Central Coast something or another, but they are very aggressive, very organized, very effective, and they are behind a lot of these measures that keep coming up in front of these government councils. And then there, to some extent, there are some tenant unions. There's a Ventura tenant union that's around that also advocates for these kinds of things. And then you have what I call property owner advocacy groups. Think California Association of Realtors, our local Ventura County Coastal Association of Realtors, property management companies. There was probably 6 or 7 owners of management companies advocating on behalf of landlords throughout this whole negotiation process. And then the final stakeholder, which is irritating, is the city of Ventura itself, specifically the staff at the city, because they push an agenda, kind of an undertone behind the scenes agenda, which is not friendly to landlords. Sometimes they run they run against what the city council even tells them to do. But it's important to understand who the players are in these negotiations. So moving on, we didn't just get here overnight. This has been happening for a while. We are not here to get political or take, right versus left. This is merely, let's educate you guys on what's happening. So in California, we have a one-party control, and that party loves tenant protections, rent control, regulation. Right or wrong, it doesn't really matter, but they are the ones that are passing these laws. Now, when COVID hit, obviously that turned a lot of stuff upside down. It accelerated all of this. It pushed us way farther down the field for these things than if COVID had never happened. But we are here. In 2019, literally right before COVID hit, the first statewide rent control bill passed. It was Assembly Bill 1482. You guys should know about this or have heard about it because it's been with us for 5-6 years now. It didn't really have a lot of teeth in it, and for the most part, a lot of people ignored it. So the state didn't take kindly to that, so they came out in 2023 with Senate Bill 567, which is like the new and improved 1482 with teeth behind it, with criminal charges, penalties, a lot of bad things for landlords. In addition to that, a ton of state laws that affect a lot of different things that you do as a landlord. We're not going to talk about all of them today because we'd be here for 5 hours, but just know that they're there. And if you have questions, reach out to us. We are happy to help guide you through this process. So that was all state level stuff. In fact, during COVID, the federal government got involved in preventing. What's that? Yeah. Oh, gotcha. So the federal government even got involved in it during COVID, but for the most part, the state is the one who pushes a lot of this stuff. And now the cities are like, hey, what about us? So they start following. Santa Barbara, Oxnard, Ojai, they have all layered on their own tenant protection measures. So we've got some folks with property in Oxnard here. This is nothing new to them. Those have been in place for, I think, 2 years now. So that's what we're trying to prevent in Ventura. We don't want Ventura doing what Oxnard did. Ojai basically followed Oxnard. Santa Barbara is a whole nother animal. They are 10 times worse than anything we have here. We want to prevent becoming Santa Barbara for sure. So Ventura's followed track with them, and these organizations are, they're championing it every step of the way. So the first thing that the City of Ventura did specifically is in 2022, they passed a just cause evictions for demolition and substantial remodel. I don't know who remembers this, but there was a case, I don't remember all the specific details. I think it was on the Avenue, it was an apartment complex where they vacated the tenants. The tenants revolted. I think that might have been the genesis for the tenant unions. I see Brian nodding his head. That might be. The City of Ventura responded and said, you can't, if you're gonna renovate your house or your rental property, you have to follow this new law. And essentially, there's a lot of details to it, and Senate 567 kind of replaced some of those, but you now have to pay 2 months rent for your tenant to move out if you're gonna do this. This was just the first stab that Ventura took at their own regulations. Luckily, it was literally just if you were gonna remodel the property and have to kick the tenants out. So that was the first time. This is in here. So there's something called a housing element. This is like a framework from the state that they dump on the cities, not just Ventura, pretty much all the cities in Ventura and the municipalities. And what it says is, and I'm paraphrasing grossly here, we have a housing shortage. There's a housing issue. It's a real problem. This is the state saying, hey, you guys better get it together. Here's some framework for what you guys need to do. And in that framework, most of it is not about tenant protections. It's about zoning and how many affordable units, those types of things. But there is a portion of it that says, we don't want tenants to be evicted, so maybe put some of these tenant protection things in place. Now, not every city bites on this and goes, okay, we're gonna do that. I mean, you still have to have the political will to do it, and a lot of cities just refuse to. Unfortunately, our city's not one of those. So what our city did was, they're basically using this as political cover. Like, we have to do this because the housing element from the state is telling us we have to address these things. So mid-2024, the staff came out and said, hey, we're trying to fulfill this housing element. Here's 7 things that we think we need to do so that we can fulfill it. Cue landlords, VCCAR, management companies, everybody going, oh no, this is like the worst case scenario. So for the most part, the people on our side kind of united and went to work at trying to slow these down and or defeat them. So these first 7 things weren't actual ordinances that the city came through with. They basically said to the council, we need to look at these things, tell us if we're good to look at these things or not. I was at that council meeting with a lot of people that are in this room here, and basically we had luck, through our efforts, we were able to shoot down right away 4 out of the 7. And those would be 4 of the worst ones for you. I'll just go through these. One was a rental registry. This is where you have to tell the city that you have a rental property, how much you rent it for, who you are, tenants information, and you have to pay a fee so you can pay them to do this to you. Very bad for landlords. Security deposit ordinance, they were trying to make it, again, there was not details because these were just concepts at the beginning. They basically want to make it to where they're going to regulate how you return a deposit, how much you can charge for a deposit. At the same time they were doing this, the state passed its own security deposit law. So this one was completely redundant. The third one was a tenant's right to purchase, which personally was like, I have a big issue with this. But if you as a landlord say, you know what, I'm done being a landlord, I'm going to sell my property. Well, you had to offer it to your tenant first, and they were going to basically tie it up for a period of time, which is completely unacceptable in my opinion. Displacement assistance is if you are going to displace your tenant, because there are reasons that you can displace your tenant, they wanted you to pay more than the state was going to make you pay. And then rent stabilization ordinance, this is the one that Oxnard has that they were trying to bring here, is the state law already lets you raise your rents roughly 7 to 8% if you're subject to the law. They wanted to make that more restrictive. So Oxnard is 4%. So this is a really, really bad one for landlords. The 6th one was legal services. The extreme form of this is the city would pay an attorney for your tenant to sue you if you're trying to evict them. Really bad for landlords. That's not where it ended up, and this is one that we're probably going to get stuck with, but we'll go into detail about that. And then the last one was an anti-harassment ordinance, which is the one that we really actually need help from everybody here still. It's not set in stone, but we're in the process of that. So that was where they started. through all of our efforts, and a lot of people in this room too, we were able, like I said, to get rid of the rental registry, get rid of the security deposit ordinance, the right to purchase, and the rent stabilization, which left us with displacement assistant, legal services, and anti-harassment. We went to work on all three of these, and we've made successes over time. It wasn't all at the same time. So we were successful in just eliminating the displacement assistance. Just to give you an idea of what they were trying to do, they basically wanted to pay 2 months rent for a regular displacement if you were just going to get rid of your tenant. I shouldn't say get rid of. If you were going to displace your tenant, and then if your tenant belonged to any of these classes, you were going to have to pay them even more. And the class was, if you're over 62, if you have children, if you're disabled, what was one of the other? Forget the other one, but they basically, it would have carved out like the majority of the population, which was ridiculous because if somebody needs assistance, it needs to be need-based because, you know, I have kids. Does that mean I'm going to be homeless if I get evicted? Probably not. So luckily we were successful in just getting that one wiped off the table. So now we just have legal services and education and harassment. So legal services and education, we were successful in watering down. So the city has a contract with an organization called the HRC, or Housing Rights Center, I believe. And basically it's like informational mediation, education of landlords and property owners. There's no teeth behind it. It doesn't really impact anybody really. So what they did basically is they enhanced the contract with them. So they're going to pay them $500,000 over 3 or 4 years to continue to do what they do, which is basically nothing, which it's definitely a waste of money, but as far as from our perspective, it's not really going to affect your business and make things really difficult for you. So that one is coming. In fact, we just, VCCAR just won at the Planning Commission 2 days ago. They're going to be the ones that do a lot of the education. The city was trying to bring in some people from LA to do it, which didn't make a lot of sense to anybody. Okay, that leaves us with anti-harassment, which is the whole reason we're here today, because this is the one that, in my opinion, is the biggest problem for landlords. They just released, so the city put out their draft ordinance months ago. We went, you know, and went to the meetings, and the way they do it is weird. It goes through 3 different groups. It goes to the Planning Commission, then it goes to the Housing and Homeless Subcommittee, and then it goes to the City Council. Well, we were able to tie it up in the Housing Homeless Subcommittee, so we brought our objections to it, and they sent it back to get rewritten with a lot of the feedback. They also did a workshop where they put in a room no different than this, all of the players that are there. So we were literally there with CAUSE and the unions, and it was not a fun meeting because it was a very, very contentious. Like these organizations, they're not opposed to yelling, screaming, name calling. Like it's not a civil process, I'll just say. So they took all that workshop feedback and then they put that into another draft ordinance, which they just released a couple days ago at the Planning Commission, which I was at that meeting along with some people here. And the Planning Commission basically said, this ordinance makes no sense. There's no rhyme or reason to it. It could be interpreted 15 different ways. So they sent it back for another redo, which is good for us. But the structural problems of the ordinance is, number one, the definition. So, and by the way, we are happy to send you guys copies of this. I didn't want to print out hundreds of pages for obvious reasons, but they define harassment as if you don't have a lawful purpose of doing something to your tenant, essentially they're going to call that harassment. And then they specifically identified like A through P, things that could be considered harassment. Some of the more egregious ones were if your tenant reports a maintenance issue and you don't fix it in time, and who determines that time is unclear, that's harassment. Or if you don't allow them to pay with certain forms of payment, that could be considered harassment. So there's a lot of problems for a landlord with this because you have to be able to run your business. You have to be able to be a landlord and conduct business. If somebody's going to categorize what you're doing as harassment, that's really bad for you. And we'll get into why. One, they can use it now as an affirmative defense in an eviction. So they can block your eviction if they can claim that you harassed them. via this ordinance and what it says harassment is. There's two, like, the teeth behind the ordinance are civil penalties and administrative penalties. So civil penalties, they got to take you to Superior Court, get a lawyer, and sue you. What it allows for is $2,000 to $10,000 per day, up to 30 days. No clarity on what constitutes a $2,000 fine versus a $10,000 fine, or how the fine's levied or when. Just it's pretty vague. So that's an issue. The other one, which in my opinion is worse, because the reality is for someone to go hire a lawyer to sue you for a $2,000 harassment, probably going to be an uphill battle because it's going to be really expensive and they have to have the money, which is difficult for some people. The worst one, in my opinion, is the administrative penalties. These are city levied fines against you that the city keeps. This money doesn't go back to the tenants. But the first offense is $500, $1,000 for the second, $1,500 for the third. Again, no process behind this. No, is a complaint made? Is the owner notified? Is there like this process that you go through? It's literally like 2 sentences in the ordinance. That's what the Planning Commission had a problem with. Like, hey, this is basically garbage. Like, how is anybody gonna make sense of this? So that's the anti-harassment ordinance in a nutshell. And I'm sure you'll have questions, which we're happy to take at the end. One other thing I wanted to note is when I said the city staff sometimes works against this process, this is a perfect example. This week, the City of Ventura just finalized their general plan, which is a planning document they use for not just housing, but all kinds of things in the city. The city staff snuck back in the tenant protections so that future councils can go, oh, we're just following the general plan. The general plan says we need to do tenant protection things. So we went through rigmarole with them and we were successful at the council meeting in getting them to amend it and get rid of those tenant protections in the plan. So that is a big win that we were able to accomplish. So the reality is what does this mean for you as a landlord? What do you have to do, or for your clients that you're working with? It boils down to you need to educate yourself or educate your clients. If you don't stay on top of this stuff, you are more than likely breaking laws you didn't even know existed, and there's real consequences for that. So this is not the same business that it was 10 years ago at all. It's a completely different business. The rules have essentially changed on us. So if you haven't updated your leases and your paperwork in a couple of years, guaranteed you're breaking laws you don't even know. So if that's the case, take some time, update your rental agreements. Even if you've had a tenant in there for 10 years, do a renewal, get yourself compliant. Otherwise, you're going to get hurt. Quick story, we had a lot of people bring problems to us that we helped them unwind, and we had somebody that needed to do an eviction. They brought it to us. We, got our eviction attorney involved, and they had never disclosed the Assembly Bill 1482 or 567 to their tenants. The eviction can't even proceed. They have to then make the disclosures months down the road before you can actually do the eviction. So if you guys know that and you haven't disclosed, let us know. We'll help you disclose. It's not rocket science. The disclosures are pretty easy, but it's that one little step. If you don't do it, you're literally screwing yourself if you get into trouble. So the other thing that is important, that was less important 10, 20 years ago, is you have to treat your activities as a landlord like an actual business, because believe it or not, you are in business. A lot of our clients are mom and pop landlords. They own 1 or 2 properties. They don't view it as a business, but the reality is you're exposed to the same liability and risks that the 300-unit corporate-owned apartment complex is exposed to. And if you ever get taken in front of a judge, you can't tell the judge, well, I just have 1 rental property. I didn't really know. That is not a defense against a problem. So you got to treat it like a business. And if you don't have the time to do all this stuff, because I'm here to tell you that to do what we're outlining here is very time consuming. Trying to stay on top of all the new laws is a full-time job in itself. If you don't have the capacity or the will, because I don't know who in their right mind would really enjoy this stuff, you should reach out to a professional, whether it's a property management company or an attorney to redo your leases, or at a minimum, join some of the landlord associations. The California Apartment Association is one of them, so that you can leverage their expertise to keep you compliant. That's what this boils down to. You have to stay on top of this stuff. So what's next for this ordinance and where we really need assistance is it's going back to the Planning Commission, then the Housing Committee, and then the council. We have the opportunity to mold it. I mean, we have the opportunity to stop it. I don't know if we're going to be able to get this one thrown out. I think this one has legs, but what we need to do is help modify it so it's palatable for landlords, so it doesn't prevent you from doing your job as a landlord. And the way you do that, call your council member, email them, go to the council meetings and speak. It's not the first thing anybody would ever want to do in their spare time, but it absolutely makes a difference. The reason it's important more now than ever is now we have these tenant groups that are out there, and I guarantee you they are doing this regularly. In fact, when I was at the Planning Commission, one of the commissioners had to excuse himself, and when he came back in, he's like, I forgot to explain why I had to excuse myself. He is employed by cause. So they basically got one of their people on the Planning Commission, which is really bad for landlords, right? Because they literally have people on the committees that make decisions regarding this stuff. So they're not going away. In fact, if anything, they're gaining more steam and they're getting more empowered. We have to counteract on the other side. Otherwise, we're going to end up like a Santa Barbara, like an Oakland or in Los Angeles, where this stuff is so onerous that landlords are fleeing. They're selling their properties and buying in Texas or Florida or other places. We are not anywhere near as bad as those places now. And, hopefully with all of our efforts, we won't get there. So that's pretty much the presentation. We're committed to keeping the people that we work with and that are in our sphere updated and letting you guys know, what's going on and more importantly, what you can do to help. If you want to talk to us about your personal situation, reach out to Kenya, Austin, or myself. We're happy to schedule something and sit down and take a look at this. A lot of the times, if you bring a situation for us to look at, it's not as easy as, oh, do this, don't do that. It has to, because the laws are so convoluted and the laws don't agree with each other. What's right in one law could be considered wrong in another. Sometimes you really have to dig in, like, who owns the property? How many properties do they own? What entity? There's like a lot of factors that come into play. That's it. So what time is it? 30 minutes. So yeah, if you guys have questions, we're happy to take them and go from there. Yeah. Thank you. Sure. Yeah.
Okay, I have a question. I live in a multi-family home, but I turned the garages into an ADU, and so I have a tenant in there, and I don't want to renew the lease in January because I have a daughter who's living in Santa Barbara, and the tenant is raising the rent so high, and so I want her to be able to come back. Would the tenant, would I require to pay for her relocation fees?
Yes. How many units is the build? Okay, so you're definitely subject to 567 and 1482. If it was a duplex and you live there, it's potentially different. But having your family move back into a unit is you can do that, but you have to pay them.
So even if I don't break the lease, if I just don't renew it, I still
Yep.
have to?
Yep. There is no such thing as like, hey, the lease is up, you have to leave. It has to be one of the reasons for them to leave.
So, in that case, how much would I have to pay her?
Well, so where's the property?
On the Rincon, on the beach?
In the can. So I think it's pretty sure it's 1 month's rent, but before, like, I don't.
I'll check it.
Yeah, we'll double check. I hesitate to just answer because it's controlled by a lot of things.
I called the county and they told me I'd owe her up to $10,000.
I don't think that's accurate, but we could happy to look into it for you.
Thank you.
Yeah.
Peter, when you were talking about the leases being compliant, we actually just renewed our lease in August with our tenant, but would that be something we would run through you to make sure and redo the lease where it's compliant with all these?
Yeah, so if you're working with us, all of our stuff's compliant. Yeah, we got it. That's the benefit of working with the management company. We have you covered on that.
Good. Oh, okay.
You're good. Yeah.
Okay, perfect.
Yeah.
Okay.
did you have a question?
I have one, Peter.
Oh, go ahead, sorry.
In the Rincon rental agreements, is there a arbitration clause? Can there be?
It's not, it's not binding. I don't think you can do that, but it's in there, but it's a mediation, I'm pretty sure. I don't think you can force your tenants into arbitration. It'd be nice.
You said there's no such thing as a lease ending. Can you elaborate on that?
Yeah, so if you live, well, first off, there is such thing as a lease ending, but not a lease ending where you have to move. Because in the old days, you used to go, sorry, the lease is up on October 1st, we're not renewing it, you gotta go. That doesn't exist if you live in a property that's subject to 1482 and 567. You can move tenants out, but it has to be, I think there's 4 approved reasons only.
Which are?
Moving a family back in, substantial remodel like the property's condemned. What are the other ones?
And if you move a family member in, there's a certain, I want to say it's 30 days that they have to.
Oh.
It has to be an immediate family member. If you do a remodel, you have to show proof of like permits being pulled, that it's actually a major thing, not just painting the place.
The other one is removing the unit from the rental market. And typically selling it does not qualify because you're technically not removing it. But that's a little bit of a gray area.
So it seems to me like a lot of these tenant protections are things that actually work against the tenants.
Oh, 100%. Yeah, that's a whole nother conversation is what they're trying to do for what the politicians are trying to do for them is having the opposite effect.
So, I guess without reviewing those, my plan is to go to the city council meeting whenever this thing gets there and explain why I'm a moron for keeping rents low. And just going through the whole litany of things that over the last 5 years have been thrust upon me as part of the vilified class. And I'm gonna tell them that you're doing this with no data of need. That's what the staff said in
Yep.
the last meeting. You're putting all these burdens on me. I've gotta be a moron to keep my rents low. And when I say low, I'm talking, I've got a lot of units that are at 50% of market. And for my long-term tenants. I'm gonna tell them if you pass this ordinance, I'm gonna start raising rents to the extent that I'm allowed to by law. And in that notice, I'm going to attribute it to your actions.
Yeah, as a landlord with these laws in place, you don't have a choice. If you don't keep it up, keep your rents at market rate, it's going to affect the value of the property when you go to sell. So if you're in a multifamily and you have 50% value and the value is derived from the income that the property produces, you're giving up hundreds of thousands of dollars because of it. So it's going to, that's why I say it has the opposite effect. It's going to force people like you to raise rents to the max because you don't have a choice. So, yeah.
Can you tell me about Oxnard? What?
Sure.
I need to know about
Yeah.
They're the worst.
So they have they're 4% basically. You can't raise it more than 4%. And Stephen, correct me if I'm wrong, it's 2 months of relocation, no matter what, correct? And it's not luckily you're not paying relocation if you're not in Oxnard and your property is not subject to 1482, you don't pay relocation. Oxnard's different. You pay relocation for any unit in Oxnard. So that's bad. They also have an anti-harassment ordinance. So we can connect offline and get you all the details, but you should be good. We're watching your back on that stuff when you're working with us. But yes.
I have 2 questions. One is, how do you find out if your properties are subject to, and my second question is, how does Section 8 play into this?
So the way you find out is this is the part that's really bad for everybody is they pass these laws. It's not like they email all the landlords or do like a big public service campaign to educate everybody. They just pass the law. So the answer is you might never, we come across people all the time that have never heard of these things before
You don't know until you get sued.
until you have a problem. But
And you're under the
yeah,
gun and
in the beginnings of the laws, they talk about who it applies to and who doesn't. What type of property do you have?
condominiums at, I have units at the Pepper Tree Condos in Ventura.
Okay, so they're all individually owned, correct?
Mm-hmm.
Yeah, so those typically are exempt from 1482 and 567.
They're
Exempt, yeah, but only if you do the proper notifications.
how, notifications to the tenant.
You have to disclose to the tenants about the exemption, which is a part of the law, which if it hasn't happened already, you're technically breaking the law. But it's not something you can't fix.
Well, we haven't renewed, I have one unit that is a Section 8, it was the first time I did any Section 8. And, we didn't write a new lease because it automatically converted month to month. We were having some issues with the tenant, didn't know if we were gonna keep them. But my understanding is if we decide we need to evict them, Section 8 is like, so what, they just stop paying and we've got a situation.
Yeah, that's a totally different scenario, but yeah.
So we've been trying to kind of find our way with Section 8, and it seems like it's really, when it comes right down to it, it's not any different than any other tenant.
In a lot of ways, correct. You just have a third party in the transaction, and like notice requirements are usually longer for Section 8 tenants. If you, happy to connect you with an attorney who specifically works with Section 8 landlord tenant issues on the landlord side, not on the tenant side.
But what you said earlier, you would recommend that instead of continuing on month to month, as it says in our lease, that it's like beginning of this year or next, whatever, that we do
New rental agreements, not necessarily a lease, but you do need a new contract for sure.
they
Like-
all say rental agreement.
Yeah.
Okay,
Yeah, you definitely need, are you managing it on your own?
yes.
Yeah, so we can help you with that. You definitely need to do new agreements for sure.
I need to figure out how many units I have to have before it's cost efficient to have a management company. which-
One lawsuit is all it's going to take, I think. No, but we can help, even if we don't work together, we'll point you in the right direction for sure.
This might be a redundant question, but how does this affect, say, a specific scenario I'm thinking of is, like, people that come in from the Palisades fire and they have insurance kind of facilitating everything?
So that, yeah, so that created a problem because the second, from my previous world in the fire department, the second a big fire happens, the governor will typically declare a state of emergency, and that enacts these anti-price gouging laws, not just for housing, but for everything. Well, and then they use these as political, the state of emergency is a political issue. Even the emergency was a year ago, they could have it still in place. So which basically means you can't raise rents any more than 10% on what they were before the emergency happened. Well, when all those houses burned to the ground, all these people are displaced. Fingers crossed they all have insurance coverage. Well, the insurance is going to basically help put them up in a rental property. Well, there's a crazy amount of competition for rental, a limited supply of rentals. So the laws of supply and demand are the price goes up, right? Well, the anti-price gouging law doesn't allow it, but the insurance company will come in regardless and say, oh, it's a $3,000 rental, we'll pay $6,000. Well, you as a landlord, if you accept that, you're putting yourself a little bit at risk of breaking that law, which is not where you want to be, because especially after the Palisades fires, the attorney general, everybody was going crazy trying to go after landlords. So that's what I'm getting at. If you're going to do this, you have to stay on top of it because there's so many landmines that you have to navigate.
I think she's also asking about terms. Like, so say you're renting to somebody for 4 to 6 months because they're displaced. Are they displaced at the end of 4 to 6 months? And like, if you're using your property as not necessarily a short-term rental, but as
So some of the laws kick in after 12 months. So on some short stuff, you can still end them, but again, it's complicated. So we would need to look at what city it's in, who the owner is, and all the specifics.
most of the stuff starts applying after.
A lot of the times after, so some people will do 11-month leases trying to circumvent some of the protections. Some of the protections that will work for, some of them it won't. Yes.
Thank you so much, first of all, for having us.
Oh, yeah, absolutely.
Great information, great presentation. So I'm looking at which property types are subject to 1482.
No, we can go into it. So it has to do with, does the owner live in one side? If the owner lives in one side, you can exempt the other one, but it depends on when. So if like the owner bought the duplex and they didn't live there, it's subject to the law. And then the owner moves in, it's still subject to the law. So it like depends on at what point the owner lived there and did they disclose it properly and all those things. But the duplex one is weird, but anything above a duplex is automatically subject to the law. Yeah. And then where it gets weird is ADUs, because a lot of people have ADUs. So there are people who say, well, no, it's zone single family, it's just an ADU. And then there are people on the other side say, no, that's subject to 1482 because it's 2 units. That's the problem with the laws, is there's so much ambiguity in them. The only real way to find out is to take a lawsuit down to the end, and that's very expensive and not fun. So, yes.
Well, I'm all brand new with this. I've never been a landlord.
Welcome.
Yeah, well, I'm doing my best. Anyway, I was just wondering if there's any type of insurance to protect you for somebody who doesn't want to pay, thinking that they've got some type of, I've had 2 people, family members that had this situation. It went on for a long time without getting payment, and I don't want to get into
There are specialty insurance products, one of which we provide to our clients if they want them, that provide against, they provide protection for eviction, like coverage of the legal cost and lost rent up to a certain amount of time. Like it's not going to pay out 2 years of lost rent, but if there are specialty policies for that, but they're not common. Like your landlord policy on your property does not cover if you have to evict your tenant. If you could have some lost rent coverage if you had like a major incident there, like a flood and they got displaced and you didn't, there's coverage sometimes for that, but typically an eviction under a normal landlord policy, not covered.
Okay, so if the tenant decides not to pay for some reason, I know COVID was one of the reasons, I don't know if that's still in place.
Thankfully not.
Okay. If they don't pay, would my insurance be able to kick in? I'm just trying to protect myself, since I'm losing protection now, it sounds like.
Yeah, so the way to counteract this is to enforce a strict rent collection policy. So the second somebody doesn't pay, in our case, rent's due on the 1st, they have a 3-day grace period. So on the 4th day of the month, we're posting a notice, usually a 3-day, that changes depending on some of these laws, that you have to pay or quit. And then at the end of that 3-day, we're filing the eviction. Where you see landlords get into trouble, which is usually when they're doing it on their own, is when they hear a story from the tenants about why they can't pay, why they're going to pay, what happened, some extenuating circumstance. That's when you get into the situations where I haven't collected rent for a year. It's usually because the landlord didn't do their job and enforced the lease.
So it sounds like I need insurance and you guys.
You definitely need insurance, which is a whole different topic, which I think that'll be one of the topics we do one of these on. But yeah, what it boils down to is you have, and we have a podcast, I don't know if some of you guys have heard it, but all the professionals we've ever ran through there, it all boils down to the same thing, is you have to treat what you're doing as a business, because it is. And the second you don't do that, that's when you hear horror stories of tenant destroyed the entire house, didn't pay for a year, and now I'm going bankrupt.
I'm self-employed for a long
Yeah.
time, so I get all the juggling acts you have.
Yeah.
Thank you.
Yeah.
What is your podcast?
It's called The Accidental Landlord, and it's literally designed to help we call them accidental landlords, but they're typically like someone who didn't set out intentionally to be a real estate investor, like they inherited a property from their family or they're moving out of town and they want to keep their property. It's designed to educate them on how to be an actual investor and view it more like a business. Yes.
Which makes me think, so if something happened to us, our daughters, of inheriting, what do you think of that?
I think it's great. That's one of the benefits of owning real estate.
Okay, but,
Yeah, the trust.
But-
As long as you have the trust in place.
but what about for them running the business?
Yeah, so it's an uphill. So like letting your kids inherit a bunch of rental properties without preparing them for that can be disastrous, right? Like it could be a problem.
That's what I'm thinking.
told them to
So
sell it, just sell it,
What,
spend
what,
it.
what would be the preference, what would be,
Well, I think it would go towards you guys doing some estate planning,
yeah.
which is where living trust comes from. The other piece of this, which I want to explore in this format, is that there's an asset protection side, which a living trust doesn't really give you asset protection. Asset protection is how you like insulate yourself from lawsuits with different entities and holding companies and those types of things. Because you are, as a landlord in California, you 100% are a target. There's no way around it. You will experience a lawsuit at some point. We've lived through multiple lawsuits, which we could probably do one of these on all the lawsuits we lived through. 99% of them are garbage, and they're just shakedowns of landlords is all they are, and or insurance companies. So protecting your assets is a totally different topic, but something that's valid to explore too.
But actually, they're preparing our daughters for running a business like this. I mean,
So
would you suggest them just sell it?
I hate selling real estate. If you talk to some real estate investors here, they almost all regret selling properties. Is this accurate? I don't advocate selling. I don't want my kids to sell our real estate. I mean, if you put a good property management company in place, that could pretty much solve it for you. If you put a bad one in place, that could be a totally different story. But I would do no different than what you're already doing, like sharing information with them, showing them how it works, what to think, how to look at things.
And they can make that decision.
But selling investment real estate, I mean, I don't like it. They'll usually take tax hits unless you do a 1031, and that's more complex for your kids to figure out. And if you do all the homework while you're alive, you can really set them up nicely. All right, oh yeah, go ahead.
Making me feel like I got golden handcuffs on.
We're only talking about the most negative aspects of being a landlord. In my opinion, the benefits far outweigh all this stuff. Far outweigh this stuff. And we're not really addressing that today. But I still think it's a great idea to get into residential real estate, even in California. In fact, I invested out of state for years because I couldn't necessarily afford to invest in California. Well, as time went on and equity changed, I don't invest out of state anymore. I only invest here, even though I know the nightmare landscape we have for regulation, because the returns are still better here than they ever are going to be in the Midwest. You just have different problems to deal with. And it's not that big of a deal if you educate yourself, figure out how the game is played, and then you play the game. Yeah. Yeah. Guys, thank you very much for coming. We want to do more of these. Thank you for tolerating us with all the tech and trying to figure it out. We're here to help. You can set up a meeting with any of us at any time. Sometimes we'll do a portfolio audit for people just to give them a second set of eyes on the portfolio. Whether we work together or not doesn't really matter. But that's always an option too, so you kind of know where you're at. Because a lot of people, interesting fact, they say 65-70% of rental properties are managed by the owner, which tells you people are doing this on their own, the majority of them, which is getting harder and harder to do as all of this nonsense develops. So anyhow, awesome. Thank you guys. Much appreciated. Yeah.
Thanks for lunch.
Yeah.
One quick question.
Yeah.
Sticking with you had mentioned in Oxnard that you only raise rent 4%. We just renewed our lease for the tennis court in August. We raised it 5%.
So
If
only if you're subject to on the rent team, so we can raise it. It doesn't